Hello, my name's Jane Anderson. I am at NYU and I'm here to talk to you today about intellectual property law and why it matters and what kinds of questions come up from a tribal perspective. So intellectual property is a term that is really an umbrella term to describe several various pieces of legislation: copyright, patents, trademarks, confidential information. Intellectual property law developed in the 16th and 17th century, largely in Europe, so it has a significant European derivation. Why intellectual property is used to link these very disparate bodies of law together is because they are seen to share some part of the same problem, which is trying to make something that is intangible tangible. One of the problems for intellectual property has always been, where are the borders and the markers, where are the fences? In intellectual property law, that has not necessarily been clear in the same way that real property has been made to make sense in terms of property and where the limits of that are. The main area of intellectual property that affects tribal institutions is copyright law. Copyright has various parts of it that affect how a tribal institution can function and the different questions in terms of who owns the material that an institution has and what kinds of decisions they need to make in relationship to digitizing their material. The main problem that tribal institutions have in relationship to copyright is that a lot of the material that was produced about Native, First Nations and Aboriginal peoples over the long period of colonisation is not actually owned by tribal institutions. It's usually owned by the researcher or the person who made the collection. So one of the dilemmas for copyright historically for Native, First Nations and Aboriginal peoples is that it grants ownership to the person who takes the photograph, who presses the button on the sound recording, or who writes down and documents a language or a song. Copyright is very particular in terms of who it vests its ownership with, and it vests that ownership with the person who is doing the making, doing the labour of making or producing the tangible version, in this sense, producing the tangible photograph, the tangible sound recording, all writing it down. This means that copyright protects some knowledge and protects some knowledge and not all knowledge, but it has a very particular and cultural perspective in relationship to who can be the owner of that knowledge.